Welcome to Digitally Legal Cybersecurity Month Awareness Seminar. Today we've got the Information Regulator Representative, Mr. Sizwe Snail, who is participating with us to discuss children's rights when it comes to data breaches and cybersecurity, with a specific emphasis on schools and the processing of children's information. So, Mr. Sizwe, could you just maybe briefly explain who you are, who the Office of the Information Regulator is, and what a stakeholder engagement is? What purpose are you actually joining Digitally Legal for?
Good morning. Thank you very much for having me at your webinar this morning. Indeed, I'm Sizwe Snail. I'm a part-time member with the Information Regulator, and I have been tasked to participate in this particular stakeholder engagement. As the regulator, we believe that stakeholder engagement is extremely important, especially now during the times of COVID-19. We have moved our face-to-face stakeholder engagement, and we are really relying upon technology such as this platform here today to be able to do stakeholder engagement. So as it is, today, I've been tasked to represent the regulator at this very important stakeholder engagement pertaining to children's rights. As you may know, it is Cybersecurity Month as well, and therefore, it is really critical that we appreciate cybersecurity as well as the rights of children, which is the theme here today.
Thank you for that, Mr. Snail. So, I mean, as we all know, children are the most vulnerable in our society. So you can pick whichever sector, whichever geographic location, any NSM grouping. Children will always be the most vulnerable. So now, when we talk about data processing, we speak about the data subject. And when we speak about the data subject being a child, is there an extra duty of care there, or maybe let's actually backtrack? So we can just give a high level on what POPI is there for. I think just for the benefit of the parents watching, the administrators and the leaders at the school, from teachers to the headmasters, headmistresses. For purposes of POPI, a data subject would be someone whose personal information you collect for the purposes of processing and to fulfill the duty of your organization. So in the case of a school, that would be, collecting from, I guess, the very inception. Admin that would determine whether the child will come in or be accepted by the school. So for interview purposes, and then if it goes to further stages for, understanding who the demographic or understanding who this child is in particular, getting specific information in the event of, an unforeseen event at school, who the emergency contacts are, any allergies. So that type of information that gives you identifiable information pertaining to that particular child. So traditionally in South Africa, there haven't been any laws that govern how this information is kept. There haven't been any laws that govern the processing of this information. And as per Section 1 of POPI, processing would be anything from keeping the information, disseminating it with third parties, processing it within the school for getting information, more intel on that particular student or the group or classes. So now, what would POPI change now in terms of how schools would generally run schools or run themselves based on what I just described?
Well, I think there's a fallacy out there to say that prior to POPIA, there was no protection of the right to privacy. In actual fact, POPIA is the embodiment, the legislative embodiment of personal information vis-a-vis the right to privacy as contained in the Constitution in Section 14. So the right to privacy has been protected. We've had several pronouncements by the Constitutional Court. We have the case of Mystery versus the South African Medical and Dental Council Constitutional Court case, where personal information was specifically discussed. We also have the case of Black Sash versus SASA, where the information regulator was also cited as a respondent. where the court specifically said that SASSA had a duty to safeguard the personal information of grant beneficiaries. So this safeguarding of grant beneficiaries would also flow to the personal information of children. Maybe to go a step back on POPIA, POPIA in essence has got 8 principles. And these 8 principles, you need to not just know them, but you need to respect them, you need to obey them. The first principle is accountability. You are accountable to those people who give you their personal information, be it the children or the parents. Number 2, you may only choose information for a specific purpose. In other words, you must lawfully get it directly from the data subject. There's also the principle of minimality that is embodied in that. Minimality means that only take as much information as you really, really, really need. Then there's the prohibition on further processing as well, which means that if my consent for particular processing, for enrolling my child at school, for allowing my child to participate in activities of the school, it doesn't necessarily mean I've given permission for my child's pictures to be used on the Facebook page, or I haven't necessarily given permission for my child's information to be shared on social media platforms in relation to marketing activities of the school and so forth. Then we have data subject participation as well. In other words, if you process my information, I must be aware that you are processing my information. We then also have the principle relating to safety and security. In other words, the safeguarding of personal information. Schools must have reasonable technical and organizational measures. Technical being their technical, their technology, basically, their hardware, their software, and organizational. So this is where now, from the headmaster to the deputy headmaster, going to the teachers, as well as the pupils themselves, they have to be educated about POPIA. So that from an organizational point of view, for the school, for instance, the lady at the headmaster's office, or the lady processing all the details of the students, must know that such information is to be safeguarded and not to be shared with anybody. We then also read together with that, we then also obviously have the right to have the quality of your information also retained. So on an annual basis, you will hear that schools want you to re-enroll your child at school. And that is most probably also in line with the information quality principle, to say there is a positive duty that you maintain information that is accurate and proper. And you also see with FICA, for instance, the bank, their FICA specifically says that they must keep this information and update it. But POPIA also has now this principle that says if you are processing information, you must regularly update it and ensure that it is accurate. Now, specifically going into POPIA, we also have the rights of children being called special personal information. So children's rights, as we know, have often been neglected in South Africa, but in terms of the POPIA really endeavors to protect personal information of children. The class of children specifically prohibits the processing of children's information unless the parents have consented thereto, or there's a clear benefit to the data subject, in other words, the child, or there is a piece of legislation in terms of which the school is mandated to process certain information. Who or what is a child? Our jurisdiction, it is anyone who's 18. You will appreciate that the age of majority has changed from 21 to 18. So anyone who is below 18 would be deemed as a child. Therefore, schools, in particular, primary schools and high schools, really need to make an emphasis as to how they store the personal information of the children and how they protect it either from cyber hacking or from unlawful use, be it from unscrupulous teachers or unscrupulous administrators at the school who may be sharing that information with other people for purposes of marketing or any other sinister reason.
Mr. Sizwe Snail, may I just ask you this then? In terms of the 8 principles that you mentioned, when it comes to, I guess, accountability and also just data subject participation, according to Section C of POPI, when we speak about the consent that is given on behalf of a child, this would be, as you mentioned, you know, because there's no capacity because the child is under 18. This would be then given by the guardian, the parent, or someone designated by the court. In this case, let's say, for instance, a parent is not proficient in English, and when they are given a form at school to process specific data, would schools be obliged to perhaps incorporate another language to accommodate the guardian or the parent or the person given mandate or to sign on behalf or give consent on behalf of the child? Would that be something that schools need to consider?
If you look at the definition of consent, it talks about willful and informed consent. Willful, in other words, you mustn't be forced to give it, and informed means that you must clearly understand what it says. If you are not proficient in English, and let's say you are proficient in Xhosa or Zulu or Sesotho, and your child is going to an English-speaking school, in terms of POPIA, you clearly could not consent to anything of the processing of your child's personal information if you, as the parent, do not understand English. You know, POPIA is very clear on that the consent must be in a language that you understand so that you willfully consent thereto. And as you correctly pointed out, the consent would have to come from the parent. A child cannot consent to giving the information out. There are some cases, some old cases, and I don't know how such cases will be looked at. If you remember from the law of persons, if a minor does certain transactions without the consent of the parent, and the minor may have been commercially active, maybe have a business, then under certain circumstances, that consent of that minor may still be valid. So, you know, we don't know what the courts are going to say about this, but this is something that one has to bear in mind. And the fact that minors are using devices, for instance. I mean, let's take the minors away from the school situation at the moment. Minors have tablets, they have phones, they want to use WhatsApp, they want to be on Twitter, they want to be on Facebook. Are they really going to go and look for their parents' consent for every single time when they upload these things? In terms of the law, they would not be able to consent. So it would have to be your parent who puts Facebook on your device. It would have to be your parent that has to give permission for these things to be done. So you need to be very clear on those issues to say that, you know, if you are going to give consent, you need to give consent as the parent, as the child is most likely not going to be able to give consent.
I think that I like the fact that you strayed a bit away from the administration of the school, and we're looking at, you know, children in particular when it comes to them being in control of devices. Are there any specific, is there a high duty of care when it comes to, let's say, application providers, when it comes to websites, to ensure that it's indeed a child who's got consent from their parent to partake in whatever activities that they're partaking in online? Is there a high duty of care now through POPI, or does the position still stay the same, that as long as they've declared and they put a disclaimer to say you need to be over a certain age, and in the event that you're not, you need to get a parent, and let's say the child knows the parent's details and they fill that in. Is there any positive duty on application providers and website providers?
Let me make this clear. POPIA has an express prohibition on the processing of children's personal information unless there is consent or unless there is a clear benefit to the child. So processing of children's information is considered as special personal information. It has its own category. It is expressly prohibited. So in the event where you don't have consent, or where the consent has not been given by the parent, then such a service provider, in the event of a breach or in the event of anything being questionable about the processing of the personal information, that service provider may find himself or herself, or it, if it's a company, in hot water if they did not acquire the consent in the lawful manner in which I've explained, which would include getting the consent of the parent.
Mr. Snail, what does a compliant school look like? So for instance, you mentioned two elements. You said from a technical perspective, there needs to be safeguards that are put in place. And you said from an organizational perspective, there need to be safeguards. So what do those safeguards look like? So at the top of my head, when I look at it from, I guess, a digital legal perspective, technical would look at software that prevents any type of breach of vulnerabilities. We're looking at firewalls, we're looking at password protections for where the information is kept. And then from an organizational perspective, we're looking at policies. So what do the policies say to keep people in line with POPI stipulations? What do the contracts that they have say with any third parties? Do they restrict any type of processing, at least from that perspective? And just also the type of information that they give back and forth and the type of requests, are they in line with POPI? And then looking at that from a training and organizational perspective. So we look, like you mentioned, it's not just the headmistress and the top administrators, but we're looking at everyone in the value chain. Are we also involving, let's say the ground staff at the school, the security guards at the school? Who's involved in this whole process, or who's not involved in this process?
I think I mentioned earlier on when I spoke about technical and organizational measures, I made it quite clear that technical refers to technology. Like you said, your hardware, your firewalls, your information infrastructure, and then organizational is really the people factor, right? The people factor means that you need to do an impact assessment, a privacy impact assessment of your organization to see at what levels do you receive personal information, how do you process same, and how do you protect same. And unfortunately, the regulator shies away from giving legal advice, because at the end of the day, we need to regulate you and tell you whether you have used the information rightly or whether you've had proper technical or organizational measures. So I think this is one of those where legal advisors such as yourself would have to go and unpack Section 19, look at what technical measures are, look at the organizational measures, and then looking at 19.2. If you look at 19.2, it talks about adequate safeguards that are adequate for that particular situation. So it's from a case-to-case basis. There is no magic wand to say that if you comply with ABC, there is no tick box. It is really from one organization to the other. What is appropriate in terms of technological things and organizational things to one organization may not be applicable to another. Hence, a privacy impact assessment would have to be done. And this should not be confused with the assessments in terms of Section 90. Those are the assessments that are done by the regulator. That is where there's a complaint from the public or a data subject to say, but so-and-so, we suspect that they're not having proper data protection practices. The privacy impact assessment really is a word that we use in practice, myself being a lawyer, when we advise clients as to how privacy impacts on the organization. So you need to sit down with the client, look at the entire organization, map out the organization, see the points of entry of information, be it at the top, be it at the middle, be it right at the bottom, at the security guards, from the cleaners, and then at all those points, you need to assess where personal information is received. If there is personal information of children, then you must also look at the prohibition and then obviously have the necessary consent in place